Dan, how are you doing today? I know you're a big California attorney, based out of California, and you've gotten some huge verdicts.
Well, Mike, yes, I've been very fortunate. We've had some huge verdicts and settlements in various areas of the law. Just in a nutshell, business litigation, I took a $2 million breach of contract and turned it into nearly a $1 billion unanimous verdict. And then personal injury, I had the highest personal injury settlement in the history of the United States, I was told. That was back in 2007. Insurance bad faith, $58 million against farmers. Employment, $38 million, and just a whole lot of them that are pretty high.
So I got to ask you, how do you, like, for example, like Jeff and I, I wouldn't say specialize under state bar, but yeah, we focus on personal injury.
Yes.
How do you go in and say, I'm going to do, a broad range of things like that?
Well, let me back that up a little bit, because I started at a big law firm, right, in Hawaii, and then in Newport Beach. And I did business litigation, real estate, fraud, just a breach of contract type of cases for the first 20 years. Okay. I didn't do PI. I did sue insurance companies. I got that $58 million judgment. But then one of my my attorneys asked if I would represent his relative. I said, we don't really do PI. He insisted, so I did. We settled for $3 million. And I thought, I felt like I was wearing the white hat. I felt like I was doing the right thing, helping somebody in need of help. That's when we switched into doing personal injury as well. So now Callahan and Blain in Santa Ana, California, does a combination of business litigation and plaintiff's personal injury. We don't work for insurance companies. We do sue insurance companies. So that's kind of how I got into doing the PI. Yeah. And I really enjoy doing it. It really makes me feel like I'm doing the right thing for people. And not just arguing different shades of gray.
Oh, yeah, definitely. And same with me. I was at the DA's office, and I was at insurance defense, and now being on the plaintiff side, it's definitely where you feel the best when working with your clients. And I know during our conversations that we've had, we were talking about how you prepare for these big trials, these large cases, and you had a really fascinating take and something that really struck me about your philosophy on just on what drives you. And I think that's something that our listeners would really like to hear about.
Well, okay, that's kind of a deep subject, but let me tell you what drives me. I read a book by Viktor Frankl called Man's Search for Meaning. And Victor was an Australian psychologist that wrote a book and sold over 20 million copies. But he, in his 30s, was a doctor, and he was in Germany. He was Jewish, and he was put into a concentration camp, as were his parents, his brother, and his wife. His parents, his brother, and his wife were both executed, or all executed, or died in the camp. What made it different for him? He survived because he saw what other people were doing, and they got despair. And when they had despair, they had no hope. They had no purpose, and they died. His purpose was trying to help other people inside the camp. And by him doing that to help others, it kept him alive. And what he writes is that it's essential to have a purpose in life that you're striving for, because that will keep you alive. So then I guess, okay, well, that's nice, but what purpose do you want to have? And it dawned on me when I was representing Beckman Coulter in a case where he won $934 million. My purpose was just to try to help my clients any way I can. But really, their philosophy was do the right thing. And that I have adopted since that trial in 2003. And I believe that the best thing you can do to have a purpose in life is to try to help others. We are in a position as attorneys where we can help others, or we can be just motivated for money. If you're just motivated for money, you'll probably get some, but not as much as you get, really, if your purpose is to help others and help your clients and to do the right thing and to do everything that you can do to help. So one thing that I do is I don't leave any stone unturned. My preparation is incredible. I will have a case in the office. If it turns out I'm going to try the case, I bring it all to my office. I get all the depositions. The attorneys tell me, read these three first. I read them. I summarize them. I prepare my examinations. I read all the depots, all the exhibits. I interlink the exhibits and the depots. And then I go over the examinations. I have those done. I do those myself. I do everything myself. In fact, I learned later that there is an unwritten rule that nobody can leave the office before Dan leaves the office. Because if I'm in the office and I'm working, I say, "Hey, Mark, where the hell is Mark? It's 8 o'clock at night." You know? So then I learned, okay, so that's the rule. Because I was wondering, why are these people still around now? Well, that's why. But because of preparation, that allows me to overcome my fear. What drives me in some of these is fear. Because when I get this case, it's about circuit boards, for example. I don't know anything about circuit boards. So now I've got to learn about circuit boards. So there's a little bit of fear involved. And Beckman Coulter, by the way, was a case about the manufacture of circuit boards. So that fear drives me intensely to prepare. And then once I am prepared, I then feel like the 800-pound gorilla. When I come into court, I just exude confidence. You know, I know the court. The courts know me. And I feel very comfortable. And the jury sees that. They can sense it, almost smell it. Then I try to establish a relationship with the jury. And I do that with my little Carney trick with voir dire. So that is when a judge first panels the jury, I'm writing all their names down, right? And then when the judge is saying, well, thank you for being here. Let me tell you what the experience is going to be like, and la-da-da-da-da-da. I'm memorizing all the names. I'm starting at the top row. Usually, you know, you have 3 6-packs, right? So I'm going down row 1, and Martinez, Smith, et cetera, et cetera, et cetera. And then until I get him, and then I look, then I get the next row, the next row. He's still talking. Now I'm bouncing over different rows back and forth. So if I miss somebody, I got it. So by the time I go up for voir dire, now I have notes, but I've worked so hard on those notes, they're memorized. So I ask certain questions, and I will go to Mr. Martinez. Mr. Martinez, I'm glad you're here. Thank you very much. Blah, blah, blah. Here's a question. And then that juror, he may be juror number 8. So I'll jump to juror number 2, over to 6, back to 14, all around, you know, and call them all by name. And they're just amazed that I can call them by name. If you call somebody by their name, there's a lot of respect there. Like, oh my gosh, he remembers my name. And it builds, if they already have confidence, you show you have confidence because you are ready, you might as well memorize their names. You don't have to remember them for a week. You only have to remember them for the voir dire, you know. So that's kind of one little technique that I do. And I've been fairly successful at that.
Yeah, it sounds like it from those results. Absolutely. I always find that very critical when the jury likes you and the jury connects with you probably, and they can feel that genuine, just your passion in the case, your knowledge of the case. I always said for my time at Allstate, I got to witness so many trials because they go to trial so much. I second and third chaired, not to mention the ones I first chair, but it was always the attorneys that were genuine, that leaned into who they were, that were the most successful.
Right. You have to be genuine. You have to just be yourself with the jury. You cannot try to be somebody else. You know, my knowledge of the English language is not as broad as some well-read individuals, you know, but I think I communicate on a level that they understand. And they can tell when I'm talking to them, I believe in everything I'm saying to them. There is one thing that I should bring up that also may drive me. So when I was in high school, I didn't do that well. In fact, I went to Immaculate Conception. I had nuns. I went through grade school there, and I had not really excelled. But when I went to high school, boy, I'm really going to do it now. And then I had a 98% average in Latin, and the nun gave me a C. I said, "You gave me a C. I had a 98%. I gave you a C because you deserve a C." Well, but then I says, I threw in the towel, so screw this. I managed to graduate 5th in my class from the bottom. That's the number 178 out of 182. 168 out of 172. And anyway, so I then worked construction for a couple of years. And I was one time climbing a tree with a McCullough chainsaw, chopping it all down and throwing it into a wood chipper. I said, what the hell am I doing here? You know, my mother said I'd be a good lawyer. My dad said I'd be a good lawyer, but I just never applied myself. So I looked at my buddy who got me the job. I know why he's there, because he's standing next to his dad. Okay, I got it. But I thought, maybe I can go to college. But that means I have to go against all those smart kids. So now, when I went to college, I thought, okay, well, these are all those smart kids. So I worked really hard, and I got straight A's. So I put all those smart kids on a pedestal, and I fought to beat that guy. So I did good in college, but okay, now I'm going to law school. Okay, hold on. Dan, you're pretty good at this bullshit at college, but this is law school. These are really the smart people. So, okay, there they are on a pedestal again, right? I went to UC Davis. I finished with honors, and I was the editor of the Law Review, and thought, okay, apparently you're good at this too, but now you're going to be a lawyer. And you're up against guys that have been a lawyer for 5 and 10 and 30 years. And also, what I learned in law school is not what you really learn in court.
Yeah.
So I thought I'd just buckle down and learn until I had an epiphany of what I'm supposed to do. I worked for 2 years at a big firm in Hawaii, 2 years at a big firm in Newport Beach, and then I went out and opened my own office on St. Patrick's Day, 1984. I had brought in a number of clients, so I thought it was a good idea. But when I go to trial, it's the same old deal. It's, does the emperor have any clothes? I better learn this stuff. So I work really hard, and I know who I'm up against. I'm up against some really high-flying lawyers. So there they go on the pedestal again. And I'm again fighting the guy on the pedestal. And by the time they show up, they're not on a pedestal. So I have an advantage because I've prepared for Goliath. So what fundamentally helps me is my fear at the beginning and my preparation. And once I prepare and I know I've got everything down, then I no longer have any fear, and I feel great. But I think it all stems from not doing so well in high school and then matching up against other people, down the road.
So is it the fear of what is the fear of? Like fear of not doing well for your clients, fear of losing? What do you think it is?
No, the fear of not living up to what I should be able to do.
Yeah.
Fear of not performing at the highest level. And if you give me something I don't know anything about, like circuit boards, and I'm not Mr. High Tech, so it's just whatever it happens to be. If I don't know anything about the subject matter, and I feel that I don't know anything about the subject matter, I damn well better learn. But once I do learn, then I overcome the fear. I don't have fear of public speaking at all.
Right.
So I love jury work more than anything else. So I love jury work. Go ahead.
Yeah. So, I mean, if you had, a young attorney under your belt and they were going for your first trial, what are kind of some tips that you would give them for like voir dire, for example?
Well, what I did for my first trial, I reviewed the work of Jerry Spence. Jerry Spence out of Wyoming. And I got his video on jury selection and opening statement. And I watched those. I took notes. I took this case over. It was 17 days to go to trial. And so I just went totally in. And I just learned from others. I go to CEB courses. I try to learn from others. And so in this situation with your first trial, it's funny. I had my first trial, and the lawyer who brought me into it was co-chairing. He said it's the best voir dire he's ever seen. He's seen a lot of the great ones. Best opening statement. But then he also, after I hit that $934 million, I called him up to say, by the way, I should tell you something. That trial we had, that was my first. Somehow or another, he had thought I had more trials than that. He said, I wonder, because you didn't know the evidence code for shit.
Yeah, I'll say what's really refreshing is hearing someone with your pedigree and these type of experiences still say when you go to trial that you're driven by a little bit of fear. Because I think as younger attorneys and people that listen to this podcast and our kind of peer group, we sit around and think the big dogs like you, they're like that. They wake up and they're ready for trial every day,
Yeah.
and it's nice to hear that. Hey, look, in some ways we're all in the same boat.
I think everybody has to have some level of anxiety or fear, whatever you want to call it. It energizes you. And if you don't have that, I think you're lacking something. So if a new lawyer has that fear, well, welcome to the club. We all do.
Yeah.
Right?
Yeah, that and the common theme, we just spoke to John Morgan, and the comments you made about having something that drives you, a mission, a purpose. We keep hearing that more and more about how just critical that is to your success, and it almost makes attorneys a different kind of attorney once they harness that.
Yeah, I feel like if your focus is just money, there are easier ways to make money.
Oh, yeah.
There's just so much easier ways, a lot less headache ways. But if your focus is to actually help people, and then this is a great place where you can help people and make pretty good money. But you've got to have a drive for it, because that's going to be the difference between you working at 10 or 11 o'clock at night and not feeling tired and being like, okay, well, next day I got to do X, Y, and Z. If you're not in it, then around 10 o'clock, you're like, oh, I'll just go to bed. It's fine. I don't care. Or even that fear that you have when you're, starting to pick a jury and you've got those tingles and stuff, that's you wanting to do a good job because you care. If you don't have that, I don't know, maybe you have no, like your threshold for pain or anything like that is like not there, or you don't care. You're like, yeah, it's fine. And if that's the case, then I think that your client probably should have went with someone else. Personally.
Yeah, I mean, everybody's going to have some nervous anxiety when they go to get up. Yeah. I know when I start, once I realize my lips are moving correctly, then I feel, okay, good. So it's working. I know what I'm doing now. So I do enjoy interacting with the jury and getting to know them and having them get to know me. During the voir dire process, I think that's about making relationships and friendships.
Yeah.
Because if they like you, when you go to do your opening statement, they're already open to receiving a message from you. And so voir dire, certainly you want to go ahead and get rid of the jurors I think will not be helpful and keep the ones I think will be helpful. And I can comment on how to do that. But after that, you really try to make friends.
Yeah.
Yeah, we'd love to hear about how to get your voir dire. And for Texas listeners, voir dire and voir dire, same thing.
I never know which was right.
Well, we don't either, but it's Texas, so we always think we're right. So.
So one of the things when you have all the jurors up there and you call them by name, now they respect you because, oh my God, they're shocked that you, without any notes, just remember all their names. That impresses them a lot. I had one guy get up behind me, said, well, I'm sorry, I'm not like Mr. Callahan. I can't remember all of your names. He did such a terrible job. He went, juror number 1, I have 4 questions. Juror number 2, same 4. And then, so you can imagine now, juror number 11 is about to go to sleep. But you have to keep them all engaged, right? So when you call on a juror, you start with juror number 8, call them by name, ask them some questions, then say, Mr. Gonzalez, you heard what Mr. Smith said a moment ago about this. Do you agree with that or do you disagree with that? Well, now they know that you went from 8 to 2. So everybody goes, I don't know if I'm getting called next. I'm going to have to pay attention.
Yeah, I need to pay attention.
Yeah. And then so also if Mr. Gonzalez said something good and say, Mr. Smith, do you agree with Mr. Gonzalez? Well, no, not really. So you don't embarrass them and say, what are you, an idiot? You just say, oh, thank you very much. You thank them for their views. Yeah. But you notice that he didn't really care for something you really liked. On the other hand, if Mr. Gonzalez had said something I didn't like, and I said, oh, well, thank you very much, Mr. Gonzalez. I'm curious, Mr. Smith or Mr. Jones or whoever, how do you feel about what he said? I don't really agree with that, attaboy. Or if he says, I totally agree with that. Good to know. So you try to find out who agrees with the good, who disagrees with the bad, and make your choices accordingly. I've had jury consultants, and sometimes they're good. I've had a couple that have really been pretty good. I've had one that I was not very impressed with, and I let him go after the first day of jury selection. I don't want to mention names, but you have to rely on yourself and your feeling about the jury, because you're the one who's going to be dancing with them for the next period of time. So,
yeah, I love that, because it takes one question, you kind of get more bang for your buck. You're asking one and you're getting positive or negative feedback from multiple sources without getting into a whole new line of question and explaining more.
Yeah.
And you're really making it more interactive.
And building that connection as well, too. Mm-hmm. I mean, that's, number one. A lot of people will go with you on tougher cases if they think you're just more credible. So building that from day one. I really like the names idea. I've got to figure out, because I've heard that before, and I've got to figure out a way to go on the fly and try to memorize them.
Listen, if I can do it, you can do it, Mike.
If Michael Scott can do it.
So I actually not very good at names. When I meet somebody, they say, "Hi, my name's Dan." "Hey, my name's Mike." Good. It went by for some reason. I have to hear it the second time. But once I have it, I just jot my notes down, and I look at the person, look at the name, look at the person, look at the name, and you got ample time to do that.
Yeah.
Right? So then you've got it.
And then, I don't. Okay, go ahead. Sorry.
Let me mention one thing.
Yeah.
I was in a trial. I'm talking to the jury, and I want to get punitive damages. And this happens to be the one that wound up with nearly $1 billion. And I asked each and every one of the jurors if the law and the facts would support an award for punitive damages. Do you have any religious or philosophical reason why you would not award punitive damages? Everyone committed to me that they would. Back in the jury room, when the jury wanted to award punitive damages, one juror said, "No, I just can't do punitive damages." Wait a minute, you told Mr. Callahan that you would. Now, it was a unanimous verdict, so we didn't really need her, but they got her to vote. And, that may be the why it came in under $1 billion. May have been her. I don't know. So but I believe you should also ask questions like that and see what they feel about big damage awards. See how they feel about punitive damages. Don't conduct yourself in a way where you're trying to look like a money grabber, but just as a legitimate question on behalf of your client, because your client's been wronged. Your client has suffered significantly, and as a result, there should be an award for that.
I think Nick Rowley's thought of brutal honesty. It goes both ways, and that includes asking the tough questions. So I 100% agree with you. You just got to be straight up with them, and it's not so much like you're trying to corner them, try to get them commit, but you're just trying to get them to understand that, hey, you're going to be asking for this. I want to know that you're okay with doing that, so that later on you don't weasel out, right? Because if you're not, that's totally fine. That is totally fine.
Sure.
We just got to deal with it as, between the lawyers and the judge. That's it. So that's a good way to do it. And yeah, I think what you're talking to is akin to Nick Rowley's brutal honesty. So yeah. I 100% agree with that.
Mike, I agree. And just you want to be honest with them and be yourself. And the more you're prepared, the more you feel comfortable. The more you feel comfortable, the more you can be like yourself. Yeah. I had this one case, kind of funny. This is the one where I represent Rico Electronics, and they're accused of discriminating based on national origin. So no, Rico hires many people. We got Mr. Chan, he's Chinese. We got Mr. Gerardo, he's Italian. We got Mr. El Jurdi, and he's lesbian. Wait, Lebanese. And I said, "Oh my God!" I fell back like a few steps. The attorney on the other side thought I was making it up, but I wasn't. I said lesbian instead of Lebanese. But the jury just died laughing, and I died laughing. But that moment of us sharing that during the opening statement just was really bonding, because, hey, okay, I'm not perfect. I said the wrong word. But at least I didn't go, "Oh God," cry. I just laughed about it.
Yeah, that's great. Just to be, kind of vulnerable like that, and let them know that, hey, not only that, now you can roll with it. You can just, hey, look, let's move on. Let's keep going.
Yeah,
That's great.
Don't make more mistakes.
Is there any time you can think of that maybe there was either something you didn't anticipate or a mistake made and you had to kind of pull yourself out of the fire? And I'm sure it was due to your preparation, but anything like that where you could share with the listeners that, man, this was something that had to make a quick 180 on here and turn this one around.
The only thing that comes to mind is when I was an associate in a large law firm, and I was second chairing a trial, and I asked another associate if he would make sure to do a demand for exchange of experts or to identify our experts.
Mm-hmm.
I came back, and next day I said, hey, did you do that? Oh, no, I didn't do it. Oh, shit. So I went to the court, ex parte basis, trying to get relief and explain why it didn't happen. They said, no experts for you. Oh. So I went to trial. We won, and I turned one of their experts into my expert. So I bailed myself out of that one. But,
yeah, that's great.
Yeah,
that's a good bail. So basically, you realize you're not bringing any experts to this trial, so you've got to take one of theirs and you just flip on the side.
Well, I had no choice.
Yeah,
it was a small case. I think the judgment was something under $20,000. Right. But still, it was an experience. What I learned is to always be prepared. You can rely on others, but you should double check, make sure it's happening. Don't just always double check. Yeah. So with my attorneys who work for me, I give them assignments, but I don't just turn my head and I just assume they're doing it right.
Yeah.
I'm kind of on them, and I'm looking at it, and I want to see it before it goes. So I guess I'm a bit of a control freak.
Yeah.
But I think if you really want to succeed, you have to be a bit of a control freak. You have to want perfection. And if you can deliver perfection in what you do, then the people who work with you will deliver perfection in what they do.
Yeah, the trust but verify.
Yeah, exactly.
Yeah, I say that a lot around the office, and no one really likes it. But you have to do it.
Yeah.
It's like, look, I trust you to do this, but yeah, I'm going to check and I'm telling you, I give you a due date, and the day after that due date, I check it. And if it's not done, I freak out. So
yeah, because it comes down on you. You can't go to the court and say, "Yeah, I know. Boy, what an idiot my associate was, huh?"
Yeah, and it's So like for example, Jeff will send me stuff to have done by my team, right? And no joke, anytime Jeff gives me some, it's like priority one. I will do that, and then I will move on to what I need to do for that day, that week, whatever it is. But I'll make sure it's done. Doesn't matter what time it takes. And send it to him for his prove up or whatever it may be. And I'll go to my own thing. Now, if it's something that someone on my team needs to do, but Jeff has CC'd me on, who do you think I'm focusing on that week? That person, like, hey, what's this done? What's this done? What's this done? And then at one point in time, I take it upon myself and get it done. Right. And that's, for the young lawyers listening, that's what you have to do. It's what you have to do. Right. Treat your, like your supervisor, your boss as priority one, and then go to your work. And realistically, we're attorneys. We work significant amounts of time, but those first 2 years, the assignments your boss does are what are going to take you to the next level, because the stuff he's giving you is stuff that's probably like right above what you've done or are doing, but you can figure out, or that's not great work, but you'll move whatever it is so you can see the big picture. So
right.
For those listening, the buck stops with you, the attorney, and then obviously your boss after that, but he can get mad at you. You can't get mad at anyone else on your staff.
Right. Well, there's as I'm listening to you, Mike, there's a couple of things that came to mind. One is, okay, let's say you have plans. Maybe you can go to a party on Saturday night, but your work is not due until Tuesday, and I'll do it on Monday.
Yeah.
So you show up on Monday, and all of a sudden there's an ex-party notice, and you're just running, doing all these things you didn't expect to happen. So now what happened to that job you had to have done by Tuesday? So you should not delay. You should stay ahead of the game and don't procrastinate. That's, I think, a big lesson to young attorneys is not to put it off to tomorrow, because you don't know what tomorrow is going to bring. You don't know if a great client's going to walk in or a big motion is going to land on your desk. So if you have time to do it today, do it today, which leaves you more time to refine it tomorrow if need be, or to catch that speeding and baseball is coming at you the following day.
Yeah.
Yeah.
And Dan, do you have any best practices with your firm or your associates that you implement time and time again, or a theme or something that you say, hey, when you have someone new come in, you say, these are the things that we do, or this is one of the many measures that we take that I have seen create success in my lawyers or in yourself?
Well, if a new client comes in, I record the conversation because one, I don't like taking notes, and two, if I later meet with an associate and I want to give him an assignment, I'll say, here's the assignment and here's what the case is about, but read the transcript. Therefore, he gets 100% of the information is relayed to me. I think that's a very good practice.
Yeah.
That's great.
There's another thing that I think some lawyers have a problem with, and maybe they can get over it, maybe they can't. But creativity in law is extremely important. You can't just go walk in lockstep through the CCP or the civil code, whatever it may be. You don't just, okay, I'll do a complaint this way, I'll have an answer this many days, I'll do my discovery. You have to think beyond that.
Yeah.
So I'll give you an example. I had a client who was an SBA lender, and he lent money to a minority enterprise, and there's a default on payments. So he wanted me to file a complaint and go and get the equipment. But we were concerned if we did that all this equipment was going to leave the jurisdiction. So what I did is I made up a document on legal size paper, and I call it Notice of Repossession. And in California, you can do a self-help repossession so long as you don't breach the peace. So I made it look like a real typed out document. I put it in the code section for self-help repossession. I made it on legal size paper. I signed my name at the bottom and had it notarized. Okay, it wasn't any more than that. So then I hired a guy. This is back in like '86, before everybody had a cell phone with video. And I hired a guy from LA to come on down with a big old camera and video. And then went to the police station, and I said, hey, we need to have an officer come with to make sure there's no breach of the peace. So I'll come with to make sure you don't breach the peace. It's okay, fine. So I hired a flatbed truck and a forklift. And we pull up to the back of this big old warehouse. The doors are wide open in the back. We come walking in as a wedge. I'm wearing a navy blue pinstripe 3-piece suit. My name is Dan Callahan. I represent the SBA, and I'm here to foreclose on the collateral belongs to the SBA. Now, your CEO, Mr. So-and-so, he's going down. If you want to go down with him, fine. But if you point out all the collateral belongs to the SBA right now, I won't go after you personally. Boom. This is. So then I show up with my flatbed and a forklift, and my forklift runs out of gas. Well, fortunately, they had pointed out a forklift that we had collateral in, so we picked up their forklift, picked up my forklift, put it on the truck, gathered everything up, and we left. I got a call that afternoon from the attorney who represented that company, and it comes down and said, wait a minute, is it all they had to do was say no? I said, yeah, that's pretty much it. I said, well, congratulations on your sting. So I have a number of these kind of stories. I don't know how much time we have, but creativity is very important. So you should be able to learn to look outside the box. Don't be constrained by just the discovery orders and rules and what you do. You can think beyond that. You have time for one more quick story?
Absolutely.
Yeah. So I represent a friend of mine from Arizona sold materials to a subcontractor who brought those to a job site in Stockton. It was urethane foam. And he says, hey, they're not paying me. And so how do I get a mechanical lien? Well, first to serve a 20-day notice in California. You have to serve it either 20 days before or after your delivery of the product. Did you do that? What's a 20-day notice? Okay, so where is this product? And so it's over there. It's in Stockton. Well, can you just pick up these barrels, drive them around the block, drop them off again, give them possession, and then go ahead and serve a 20-day notice? No, they're locked up in a warehouse. That's not so good. So, okay, wait. So in my conversation with him, he said that he was selling them to Midstate on credit, while Midstate cannot pay their debts as due. And I remember from the UCC that if you sell goods on credit to someone while insolvent, then you can reclaim those goods and get constructive possession. So I sent a notice to reclaim those goods. I got constructive possession. Then I did a 20-day notice, and then I released possession. And they had never left the warehouse. So the attorney for the company that had the jobs done, they thought that was ridiculous. However, I went to court in Stockton, and I went to the presiding judge. I said, you just have to follow the bouncing ball on this one. Bottom line, we got paid in full. So the owner of the property didn't listen to me when I said, don't pay mid-state. And now he had to pay us twice.
Wow.
But that's creativity, right?
Yeah.
I just grafted the UCC onto the mechanic lien statute. So if I was just going by lockstep, I said, you're done. You didn't do a 20-day notice, you're toast.
Yeah. Well, I mean, isn't that exactly what law school teaches you? You take take the law, you take a fact pattern, put them together, you figure out how to make it work.
Figure out the best way for your client. So,
yeah.
Well, I agree with you that a lot of attorneys are kind of stuck with the main state of, here's the civil procedure, and in Texas we have the Civil Practice of Remedies Code, as well as the Rules of Procedure, and just kind of follow that, and then get your stuff ready for trial, then Rules of Evidence. But that's a baseline. That's for you to understand the rules. Then everything else is whatever you want to draw, whatever you want to paint, whatever you want to do in the middle, so that when you go to trial, you can do stuff within the realms of the rules, right? And so that's the biggest thing. I 100% agree with you. We had Teddy on. He said something that I really liked. It was something along the lines of, the rules are good and all, but look, if something's really good for your client and it's somewhat relevant, use demonstrative evidence and try to bring it in that way. Don't just say, oh, I can't figure out a way to get it in, so it's gone. No, if it's good, figure out a way and try to, paint the picture. That's 100% right.
So for the young lawyers, what they should be getting from this conversation is preparation is key. Yeah. And don't delay in getting things done. Don't be afraid to think outside of the box, and also put your client's interest ahead of your own, and strive to do the right thing. Strive to help your clients win, whether they're a defendant or they're a plaintiff, no matter which side of the plate you're batting from. Just try to do what's appropriate to help your client. And the more you do that, the more happy you'll be with yourself as an attorney, because you're going to be achieving success, and your clients are going to be very grateful for what you've done.
Yeah, that's awesome.
That was perfect. Dan, if anyone wants to get in contact with you, what's the best way to get in contact?
Callahan Consulting. So I've told you about Callahan and Blain in Santa Ana, my law firm, but I'm also working with Callahan Consulting now. And what we do is two things. We mentor young attorneys. We meaning me, mentor young attorneys, or like I used to do with the firm when I was more active with that firm. So I mentor young attorneys, associates, partners. I also do something else, and I do that in trial strategy and practice and just thoughts. Yeah. And for that, I charge an hourly rate. And if they just want me for an hour, okay, you get my regular rate. You want several hours, I'll give you a deal. But I also do something else, and that is that I work with clients throughout the United States. And if they, let's say just the other day, I had one in Detroit who needed a bankruptcy attorney. So I researched who was probably the best ones, or some of the best ones, in Detroit on bankruptcy. I talked to them, see if they had the manpower ready to handle this kind of case now, and if they're going to do it personally, or somebody else down the road, associate paralegal, is going to do it. And once I felt comfortable with them, then I take usually just two, sometimes three names, and I go to the client and say, these are the people I talked to. Why don't we get on a conference call together? We'll interview the lawyer, and then you make the decision. And I'm compensated with a referral fee. Some lawyers in certain practices don't pay a referral fee. I do it anyway because I'm just what I do. So that's the two things that Callahan Consulting does. Wow. And how to get a hold of Callahan Consulting? Dan at CallahanConsulting.com. The telephone number is 888-570-0000.
Got it. And
Or my cell phone, which is 949-584-4434. And just so people know, if they call my cell phone and I don't recognize the number, I don't answer. However, if they leave a message, then I listen, then I call them back.
This is what everybody does nowadays.
Right, yeah.
Okay, perfect. And we'll put that in the show notes as well, too.
Good. Thank you.
Thank you so much for coming on. I appreciate your time, and thank you for helping young attorneys out there every day.
Mike, my pleasure. Jeff, pleasure to chat with you both.
All right, thank you, Dan.